Hello, everyone, and welcome to One Civil Law. For today's story, we pick up with the Take Care of Maya case, a case that we've been watching during the trial and certainly following since. Maya Kowalski, at the time under age 18, went to Johns Hopkins Hospital with some fairly interesting symptoms. And it's not exactly 100% clear exactly what the doctors thought there, too, relating to exactly what their diagnosis was, because Johns Hopkins didn't really take a position, even in trial, exactly what they thought, which is weird because like what they thought would go a long way to, their medical negligence or lack thereof. But they didn't really take a position. And it seemed like actually they couldn't take a position because no matter what position they took, they would lose, which was kind of part of the problem after we sort of figured that out. But anyways, what happened is Johns Hopkins kept her without legal permission. And they kept her, and then they mistreated her in ways that were very concerning. They also made statements relating to Maya and her mother that apparently, at least the jury thought, caused her mother to self-delete on the apparent belief that if the mother was no longer in the equation, that Maya would be free, right? So it's like the mother seemed to believe, based on statements from Johns Hopkins or, people working at Johns Hopkins, that, as long as she was in the picture, that Maya would never get any peace. And basically she might have ended herself to save her daughter, is sort of the idea there. The jury awarded more than $200 million in damages. We have sort of commented on this in a number of different ways previously in the past. The cause of action relating to Maya's mother's death, the wrongful death for Maya's mother, remains the most legally problematic, in my view. There's a problem of causation. They didn't owe any duty to Maya's mother. They owed duties to the patient. They owed duties to Maya, but they didn't owe any duty to Maya's mother. And self-deletion has often been seen in law as an intervening act that breaks the chain of causation. So there were some legal problems there relating to that, and about half the damages are relating to that. So if that cause of action disappears, the amount would be sliced in half. And then, of course, even with the remaining counts that are there is still a viable case to be made that the jury awarded more than is legally allowable. And one of the ways that you could determine that is by looking at comparables. Now, how you find comparables in a medical malpractice case can be a bit tricky because what case is really like in the other case. But there's at least some argument to be had that this case is wildly outside the norm of the comparables. Now, that might be because this case is wildly outside the norm of the comparables. Maybe it just is that way, but there's at least a case to be made. So Johns Hopkins has some pretty reasonable arguments, it seems to me. They have a very reasonable argument, it seems to me, on the law relating to the death of Maya's mother and their lack of legal culpability there too. And they also have some pretty interesting arguments relating to excess amounts. And so we're going to watch this Court of Appeals decision, or this Court of Appeals argument rather, and we're going to watch the attorneys sort of flush these arguments out, and we'll comment from them as well as we can about what we think is going on. So yeah, so let's go ahead and get started with this.
Rebuttal time for the appellant, we will limit to 5 minutes. So if you are ready to go, let's proceed.
Good morning, Your Honors. May it please the Court. Derek Steichleather on behalf of the Appellant Hospital, and under Judge Lowe's direction, I'll have 5 minutes for rebuttal.
Very well.
The $261 million verdict in this case sprang from 3 clear legal errors. And if I could take about 90 seconds to give an overview of what those errors were and why they denied the hospital a fair trial. I'd say first, the plaintiffs were allowed to accuse the hospital of causing the suicide of a patient's mother 3 months after the mother had last set foot in the hospital. Second, the plaintiffs were also allowed, without any competent evidence to prove any of the elements of insurance fraud, to repeatedly accuse the hospital of engaging in fraud, lying and stealing from the family that sought care at the hospital. And third, the trial court profoundly misconstrued the protections of Chapter 39 immunity, limiting it only to reporting immunity and conduct at the dependency court proceedings. These three major errors set the stage for wild allegations that this is a hospital that kidnapped and tortured a little girl in order to kill her mother. That did not give the hospital...
Well, not necessarily in order to kill her mother. That wasn't necessarily their goal. We're not accusing them of murder, right? If they were trying to kill her mother, we'd be talking about something different. So I'm not quite sure that's what we're talking about, but okay.
A fair trial. And a retrial is necessary that does not include claims that we caused the suicide of a non-patient, that does not include unsupported claims that we engage in insurance fraud and steal from our families, and only follows a proper application of Chapter 39 such that the hospital is not held liable for conduct that is protected by the order of the legislature, and even for conduct that wasn't even hospital employees or agents, that was state actors.
Well, no. That's part of the problem. Like, whether or not they were agents of the hospital is an issue of fact, right? Because that's a potential question, and it's not clear necessarily, because you have this person who has a government capacity. And so the question might be, well, were they acting within their government capacity, right? Just because you are a government employee does not mean that everything you're doing is necessarily within your role as a government employee. You're not necessarily a government employee all the time. Sometimes you're just the guy, right? Sometimes you're just the guy. And of course, there's the government employee could become a private actor, and incidentally, vice versa as well. We've just sort of discussed that, how private actors can become government employees because they work too closely with the government, for example. So whether or not she was an agent of the hospital is an issue of fact, not an issue of law. So I don't really see that. As to the immunity issue, I don't really see it either. I think the judge parsed it correctly as far as I can tell. Maybe there's a nuance in here that to be had, but there is immunity for making the report relating to potential child abuse. And there is also immunity for fulfilling any order that the court makes as a result of that determination. So you don't get in trouble for the report, and you don't get in trouble if the court makes an order and then you do that thing, right? Because the order is from the court, and you can't be like blamed for that, obviously, because the court is the one ordering it. But the problem here is that they went beyond the scope of the order. That's part of the problem, right? They did things beyond what the order had. And I think the judge parsed it about as closely as you can get. I mean, it's a fine scalpel kind of thing to scalpel around those edges. But the judge seemed to really try as best as he could to try to really keep the immunity, within its bounds. And immunity is to be narrowly construed. So the judge is trying to and should construe it narrowly, because immunity by its nature, right, prevents you from having legal accountability. So immunities are narrowly construed. And so the judge seemed to try to construe them narrowly. So it seemed okay to me. So I don't really buy the Chapter 11 argument from Johns Hopkins unless there's a nuance point to be had. Maybe there's a nuance point to be had, but I don't see it. As to whether or not, the government employee was an agent of the hospital, that's a question of fact. Don't really see that working. As to the issue of Maya's mother's death, though, still remains the best cause of action for the hospital. So let's see what else they have to say.
Your position as far as the immunity, obviously you feel that the statute's too narrowly construed. How would you view the immunity that the hospital arguably is entitled to?
The immunity first expressly covers any act authorized by Chapter 39.
Yeah.
I think that's the first important point because the judge said it covers reporting.
Yeah.
From there, the authorizations, Chapter 39 is a voluminous chapter, and the legislature has said that this is a robust immunity. Courts have said this is a broad immunity, and there are very strong public policy reasons for that. I think particularly relevant here, there are immunities granted under Section 39-303-3, subsections A and subsections F, that apply to the Child Protection Team. Dr. Sally Smith, in this case, is the Child Protection Team Medical Director for Pinellas County. She was actively involved in what were child protection activities throughout. Subsection A in 39-303-3 gives her the power to diagnose and evaluate a patient. It gives her the power to order laboratory tests, to perform x-rays. And subsection F gives her the authority to collaborate with the treaters to develop a treatment plan.
You would agree that even with the immunity, that if there were an intervening tortious act by the hospital, that would not be covered under that immunity?
It would depend on what the act is. The problem here is that much of the immune conduct was just labeled tortious. You tortiously...
Well, let's just take the claims as they are, the intentional infliction of emotional distress. If that did indeed play out, then would that be covered under the immunity as you've just described?
I think a true case of intentional infliction of emotional distress would not. And I think what your question is getting at is this an absolute immunity? If a child is being protected, anything goes, and that is not the position of the hospital.
Right. So if it's not an absolute immunity, then the question are what are the boundaries of it, right? And you have to figure, and he says it's a broad immunity. Okay. I mean, in some senses, I suppose it might be, but it still has limitations. And so the judge is like, well, here's the limitations and when you went outside those bounds. So, yeah, I mean, unless it gets down to into a precise thing, right? But it doesn't. I don't think the Court of Appeals is going to go out of their way. I mean, they could, but I don't think the Court of Appeals is likely to go out of their way if this is, a marginal decision by the judge, right? It's a question of law, to be sure. So they can do whatever the hell they want. As to where the boundaries are, that's not a question of fact. That's a pure question of law. So the appeal court can do whatever the hell they want in terms of determining where the boundaries are. But I don't think they're going to go out of their way for a marginal decision. Plus, of course, it has to actually matter on top of that. So not only did the trial court have to get it wrong, but it actually has to manifest in some way that would matter. And so there's that too. So, yeah, okay.
It is certainly possible that intentional torts can be inflicted upon someone and there would be accountability. I think a good example on the medical malpractice side was that if a patient had appendicitis and Dr. Sally Smith performed an appendectomy because she's skilled as a surgeon, and this is hypothetical, of course, but if she performed an appendectomy and botched it, you could bring a medical malpractice case saying, well, that's not child protection activity. But what the hospital was held to account for here was Dr. Sally Smith is going around and asking questions, and she's rude and she's weird and she's got this raspy cigarette voice, and I'm trying to clean up my child and she's asking me all these questions that don't really seem related to what we're there for. That's core investigative child protection activity.
Well, let's go. Can we go to the intentional infliction of emotional distress claim by the estate?
Yes.
Okay. There's a case of Nelson, which I'm sure you're familiar with, because you're relying on it for the intervening cause of the suicide, that would absolve any liability by the hospital. And so in looking at Nelson, it allowed a claim of suicide to go to a jury, right, because it remanded for trial. And so it talked about the difference between one being driven to suicide versus the actions and circumstances, and I'm paraphrasing, but driving one to be mentally ill and then that person on their own volition committing suicide. And I focus on that because that distinction is the issue. I believe the court in that case is why they took it and it became a jury question. Why do we not have that same jury question here, where the facts are that we have the hospital's position was that Mrs. Kowalski was, we had the Munchausen, I think I'm pronouncing that correctly, by proxy. And so they've already indicated that there's a mental illness there. I believe one of the doctors had mentioned, his name is escaping me now, but I believe one of the doctors had...
This question bothers me as an attorney professionally. This is a little rambly for my taste. It's like, what are we talking about exactly? What exactly is the question now? I'm not even sure anymore. We were talking about Nelson for a while. It sounded like you were going to ask him to distinguish, and then we moved on to other topics, and I'm confused now what the question is. Okay.
I mentioned that she was in some sort of mental state, as maybe had relayed some information to them to that effect early on upon the admittance. And then you have, after that, you have...
Jesus Christ, this is one of the more compound questions I've ever heard in my life. It's like, how many parts does your question have? Yeesh.
And I realize that while they're not direct, some of this isn't direct to her, but you have statements by Nurse Beatty to the husband saying, why don't you divorce her? You have statements that the daughter's faking it. You have, my mic is going out. You have some allegations of interference with her religion, and it was noted that she was extremely religious. And you have them challenging her medical profession as a nurse, and then challenging her as a mom for the way that she treated her daughter. And my point to all of that is that's like everything of the woman.
Yeah, Your Honor, I have a clarification question. What?
That's like her whole existence. It wasn't just one thing that she was being challenged on, it was all of those things. Why is that not enough evidence on the issue that was in Nelson that they remanded for, not enough to go to the jury?
I think the most important distinction is that Nelson versus Seaboard is a FELA case, the Federal Employers Liability Act, and that has a almost non-existent causation requirement. FELA cases, the instructions that go to the juries are, if you find even in the slightest that this caused, you can find liability. It is significant that this is a 1980 FELA case, and we don't have a case in the following 45 years where a Florida jury has been asked to find someone liable for causing the suicide of someone who there's no clear duty owed to.
Yeah, that's a big problem, right? And so, like, the answer was actually pretty simple to the very long question. The relevant the question, and his answer is the right answer to the question. So he understood the question, thank God, and is giving the right answer. So that question that case you're referring to, Nielsen, was under a federal statute that had different requirements. It's like, cool. So, in that case, you're under that statute, and now you're in Florida law where this has not ever been recognized by Florida, like ever, right? The Florida jury hearing about a federal cause of action is definitely not the same thing. So basically, a Florida jury has never recognized this cause of action under Florida law. So, yeah, that makes it pretty different. Maya had federal insurance, but she's not suing under the federal law, so it's irrelevant. It's irrelevant, right? Her cause of action was not FELA. It was nowhere in the complaint, so it doesn't matter. No FELA complaint, no FELA statute. It's not illegal for a hospital to tell someone that if they died, their loved one would be released. No. And no liability of the loved one does after? Correct. Right. Correct. That is my best understanding of the law. Yeah. It is not illegal to tell someone that if they die, their loved one will be released. No, that's not illegal. And it is no liability if the loved one does so. Correct. Because suicide is seen in the operative law as a intervening cause of action, an intervening cause that breaks the chain of causation from the tort. So, yeah, that's right. How? Why? I just said how and why. I literally just said why. The suicide, as a matter of law, is seen as an intervening cause of action that breaks the chain of causation. That's why. Okay.
And I think that the other part of your question I'd like to address is, how do we not feel for a mother who's accused of abusing her own child? And that ingredient is present in every single child protective action that the state and pediatricians and social workers ever take to separate a child from a parent. It is always traumatic, it is always awful, it is always terrible.
Well, then on that point, following up on Judge Smith, if the hospital's operating under a shelter order, to what extent and what is the nature of any duties or obligations they might owe to the parents?
There are profoundly different obligations. I think one of the core principles of child protection law in Chapter 39, and we see this in the case law, the duty is to the child. This law exists for the benefit of the child and not for the parent.
Lack of duty is a huge problem, right? Lack of duty is a huge problem. The hospital owes no duty to the mother. They owe a duty to the child. The duty is to the patient. The duty is to the patient, right? That's how you get to negligence. In order for you to have negligence, you need to have kind of a couple things. You need to have duty, you need to have breach of that duty, you need to have causation, and you need to have damages, right? If there's no duty, there's no negligence. It's not possible. It's a fundamental element of the negligence tort, right? So you can't get to negligence because I owe you no duty. I owe you no obligation. In terms of intentionality, it's like, well, the thing breaks the chain of causation. So yeah, I mean, they owe no duty to Maya's mother. That's true. Right.
Because the parent is always outraged, is always upset, whether the allegations are true, whether the allegations are false. They are going to be devastated, furious, and they are going to sue. And because of that, we have a history of healthcare providers who are very chastened, very nervous to get involved, because the entire history of child protection legislation since 1963 in Florida has been, you need to get involved, and when you do, you will be protected from litigation.
But don't you have to balance that with a parent's, and we're talking about a minor, 10-year-old minor. Don't you have to balance that with the parents' rights that they have with the hospital? I mean, they're the parents of the minor child who's a patient in the hospital. And can't this coexist?
They can coexist, but the legislature has made a clear policy choice, because in all of these cases, there is this fear what if I'm wrong? Or what if I'm right, but there just isn't the proof? How much blowback is there going to be? And the history of these cases across the country is there is very often fierce and intense blowback. People are angry about this, and if this is allowed to go to a jury will be angry about this. And the testimony at trial amounted to, if you're going to accuse someone of child abuse, you had better be right. And the entire history of child welfare law is that is fundamentally wrong. It is the exact opposite. It is that if you have merely a reasonable suspicion, you have to report, you have to get involved. And doctors now face risk of losing their licenses. They face criminal liability.
Let me ask you this. Was there anything in the, I think there were 5.
They face criminal liability if they don't stay within the bounds of the statute. Right? The statute is not made of putty. It's not made of rubber. Okay? The statute gives them certain protections. As long as you stay within the bounds, you gain your liability shield. If you go outside the bounds, you're no longer protected by the liability shield. So doctors have to stay within the bounds of the statute because that is the basis of their protection. Right? So, yeah. I mean, you got to stay within the bounds, man.
Orders. So was there anything in that limited the parents' rights to be informed of Maya's treatment or participate in those decisions?
The parents were included that they would have decision-making authority. It is necessarily a massive limitation of their rights as parents when the child has been removed from the state and is being sheltered in another entity, and when the reason for this is the good faith belief. And I want to emphasize, good faith is an important limitation. You are not protected for bad faith actions. You're mad at your ex, you're mad at your neighbor, and you accuse them of child abuse to mess with him. That is not protected at all. This is good faith child protection activities, and there is an inevitable conflict. These are always awful, terrible, raw, sensitive.
It didn't remove the parents' rights to be informed and to be involved in the decisions.
You tell them, Judge. You tell them, right? You tell them, right? That was her question, and then he kind of ignored it. And the judge is like, nope, let me ask it a second time, right? Did they remove the rights of the parents to be informed and involved? Well, no, Your Honor, but these are complex situations and blah, blah, blah. But the court didn't order for them to be removed. So they went outside the scope of the order now, didn't they? Right? Well, it means being removed it's inherent. Like, no, it's not. No, it's not inherent. No, it's not inherent. It's based on the court order, right? It's either based on the statute or it's based on the court order. It's not like inherent. Either, there's a statute that says when a child is removed XYZ, or the order from the judge says, well, the child is removed, therefore XYZ. You can't just say, well, it's inherent. No, it's not. All right? It's like we were doing things beyond it because it's inherent in the removal. Bullshit. Nope.
Certainly not as an absolute matter, but there is, for instance, when they want to do video monitoring, they want to have the child in a room for 2 days to monitor without her knowledge, just to see, because they're repeated from the immediate outset, vast discrepancies between what they're reporting she can and cannot do and what they're observing with their own eyes.
And that was something that I believe through the testimony was approved through risk management?
Yes, an assistant risk manager approved of that.
And
What's the difference? What does the hospital use as a guide to interacting with the parents to get consent or at least inform them? And in the case of the monitoring, just doing it on their own, the advice of the people who are involved in interacting risk.
A lot of these Chapter 39 orders give this discretion to the hospital. They say the hospital has these rights, these rules are in place, the parents have these rights, but all these things like visitation, care, this is going to be done as seen appropriate by the hospital and consistent with the best interest of the child and the best interest of the care. When the theory of the case, the theory of the detention is the mother may kill this child. The mother not only, and this is not a case of a parent who drinks a case of beer and starts wailing on the kids, where simply physical separation solves it. This is a psychiatric dynamic that's going on between the two, and that's the leading theory. And the mother is not the patient of the hospital. And if it's presented as a medical malpractice case where, well, did you have advanced psychiatric experts? Are you absolutely certain the mother had this problem? That cannot be the standard. The hospital has to have...
How is it, I'm trying to get my arms around this, how is it in the best interest of the child to videotape her to prove their theory when the risk was that if she was incapable of getting out of bed, they would rather her fall to prove that the mom was right, or to prove that she actually was a victim of Munchausen by proxy?
No, there's no desire to create a fall or anything like that. And that among all the conspiracy theories, that has not been suggested that they wanted the child to fall. The idea was there is necessary for medical and for child abuse investigatory reasons to find out why is there this very strange, immediately apparent discrepancy between what they say the child can do and what she does right in front of their own eyes. There is a vast difference in her behavior from when the mother is in the room from when the mother leaves the room. They are presented with a bizarre situation. This girl shows up and the mother reports she has been put in a ketamine coma that we took her to Mexico to do because they're not done in the United States. And we've been taking her to a doctor who advertises on the internet as nopainhannah.com, and he's pumped her with 55 ketamine infusions at levels that are 10 to 100 times the amounts that this hospital would ever give a child.
That was under the direction of a medical doctor here in the States. The referral was, right?
The referral to Mexico? Or
No, I think the referral to the doctor, was that under the advice of a medical doctor?
Yes.
That she was being treated by?
You can find doctors in Florida that will sell you pain medications, and they got a $10,000 ketamine 4-day treatment from Dr. Kirkpatrick. Dr. Hannah sold them ketamine at least $1,000 a pop 55 times. The Mexico ketamine coma was $40,000 plus. There are doctors who will sell you high-powered pain medicines and prey upon vulnerable families who are desperate for some solution. And everyone loves an easy solution. Ketamine's a magic drug. This will fix your daughter's problems. And the healthcare providers, when they are presented with this, they call Dr. Hannah. They ask, we're getting these reports, what's going on? They ultimately agreed to titrate her down, but to give her these high levels of ketamine that were the same levels that put her into a coma just a year before. But her tolerance has grown so high that as her mother writes in a blog, writing in the first person as Maya, I'm taking enough drugs that would kill a horse. I mean, that's not hyperbole. She's taking...
Look, I mean, this is like the thing, right? I think like Johns Hopkins, there was a universe in which a lot of what they did was, well, to be quite honest, even in this universe, there's probably a lot of what they did that was legal, right? This doesn't necessarily have to be like completely all black and white, right? It doesn't necessarily have to be like every single thing they did was illegal or every single thing they did was in bad faith, right? I think there's a very reasonable universe where this patient comes in and John Hopkins, using sound medical discretion, calls some bullshit on what has been done to Maya, right? I mean, some of her treatments were cray bizarre, outside the norm. Now, that isn't to say that they weren't justified and right. What it is to say is that it is very reasonable to imagine that the reasonably prudent doctor, you know, the normal, average, ordinary doctor of normal, average intelligence, as we do, right, might look at this and be like, this is some nuts bullshit, right? This doesn't make any sense. I have a lot of questions. I think there's some bullshit going on, all right? And John Hopkins might have been very justified in making the report. And they might have been very justified in making that concern apparent. And they might have been very justified in following the court's orders relating thereto, right? The problem is they went outside the bounds, right? The problem is they did other exciting things. They did other exciting things beyond those things, right? If they had just stayed within the box, right? They probably would have been okay, but they did other exciting things, and now they have a massive legal problem. So, you know, stay within the box would be nice, I guess. That's what I'm saying.
Massive amounts of ketamine because she's built this high tolerance, and the care providers are gobsmacked by this. They do the due diligence, they file a report, it is found as a matter of law. They had good faith reasons to file this report.
Sure.
It is immune conduct.
For the report,
but
great.
Yet, the entire and they also won summary judgment on civil conspiracy. They won summary judgment on malicious prosecution, and they won summary judgment on intentional interference with the parent-child relationship.
Okay.
Those were all proper, and none of those are being challenged on appeal. They won those, and what they had to do was defend a medical malpractice case that made all of those same claims. You're interfering with the parent-child relationship. This is malicious prosecution. You just don't like this mother because she challenged your opinions, and you're out to destroy her. And what that...
Your end game.
I think the end game is that...
You want a new trial? Do you want to, if we agree with you, a new trial or strike through various damage items?
We certainly need to strike through the suicide claim. That is not appropriate. There is nothing remotely close to the level of extreme and outrageous conduct beyond all possible bounds of decency, conduct utterly intolerable in a civil...
Which also, to be fair, on an IIED claim, I mean, I sort of understand that argument too, right? So, like, a lot of the things that Johns Hopkins said were not good, but I mean, there is a point to be made. IIED, intentional infliction of emotional distress, is a disfavored claim. It is a disfavored claim. And the courts have, for free speech reasons, incidentally, by the way, for First Amendment reasons, it's a disfavored claim. I'm allowed to say all kinds of shit to you. I'm allowed to say all kinds of bullshit to you. I'm allowed to ridicule you. I'm allowed to mock you. I'm allowed to like deride you. I'm allowed to do all kinds of things in the name of the First Amendment, right? Or if not necessarily to you, I can say them about you or whatever, right? So like I can do all kinds of shit, right? We're very concerned about people bringing claims illegitimately, or not necessarily illegitimately, but just in a way that would break other principles we're really concerned about. So he's not wrong to make the argument. I mean, you could disagree with it on this fact pattern, to be honest. You could disagree with it, but he's not even wrong to make the argument that nothing the hospital did vis-a-vis the mother would amount to conduct that is beyond all pale, conduct that is beyond all bounds of decency, conduct that is beyond all, you know, reason and morals and beyond what society is going to tolerate. So he's not making an invalid argument when he says that. It's like, yeah, you know, you can say some shit to people. It's like, you know, you're allowed to say to somebody, you should divorce your spouse. People say it every day. You're allowed to say to people, you know, I don't think you're a good mother. People say it every day, you know, so, and so forth and so on. And so like, yeah, I mean, to some degree, yeah.
Community. This is child protection activity by licensed pediatricians, healthcare workers who admittedly have an honest disagreement with the family over what's the proper medical care. The actions of Sally Smith are entirely immune. Those are Child Protection Team medical director expressly authorized actions. The hospital cannot be tied to her and have to defend Sally Smith's conduct as the face of the hospital. The retrial, to answer your question more directly, cannot include claims of insurance fraud. This was put in purely for the poisonous effect it had on the jurors and the effect it had on their view of the hospital. This is a hospital that lies, cheats, and steals from its patients. It's rotten to the core. And when it got to closing arguments, the plaintiff said, you know what, just give us $1. Because we don't have the evidence of this. They're thrilled they were able to say it for 8 weeks, but we don't have the evidence, just give us $1. The jury gives them $5 million, even after the plaintiff's request, just make it $1. And in the briefing, you see that the plaintiffs still argue that the IIED claim is supported by the evidence because of the evidence of fraud. You know, this jury could have found it because of the fraud. This was you don't bring a $1 claim unless it's going to deliver something. And this delivered immense prejudice against the hospital. So that's the second part of what a new trial can include. I think the third part is that the new trial must follow proper application of Chapter 39, which will sharply limit the type of evidence that can come in at the retrial. So much of what was presented at the first trial was immune Chapter 39 conduct, even conduct by child protection team workers going in and confiscating this food, taking away the sacrament. I mean, things that are very sensitive, taking away her laptop, taking away her cell phone. These were actions done by state actors, or whether they're contracted through Suncoast, but non-hospital actors as part of their child protection duties, and they are.
And we're the ones you just laid out here. Were those specifically laid out and authorized by the dependency court orders for them to do?
Burn. Right? That is a great question from the judge. That is a question like burn, right? Was it all authorized by the court order? If the answer is no, then didn't you go outside the bounds? Burn.
I don't know that the court says iPads, but the actor, it is the child protection team that is making these decisions.
You're saying simply because they are a child protection actor, whatever they do and they think is right is immune.
This judge hates you. This judge hates you.
I'm saying that A, they're certainly not the hospital. B, the immunity should be broadly construed as a robust immunity, and I think there's a very strong presumption that when.
What does that mean exactly when you say robust? Is there a case authority that talks about that, or what does that term mean to you?
I think it means that it reflects that there is a policy.
I know there's specific good faith requirements in 39.
Yes.
But I don't know that's defined anywhere.
Yeah, I mean, and the word robust actually, I think, comes from the trial judge himself when describing the Chapter 39 immunity before failing to apply it. I think it goes to the idea that.
I mean, I'm not sure how, the trial judge failed to apply it. I mean, you're not even, really giving me specifics. Maybe it's in your briefing because you don't get much time in oral arguments. So maybe it's not, maybe it's in their briefing. But, how the judge failed to apply it, I mean, the judge certainly tried. The judge tried, which isn't to say that he necessarily got it right, but he tried. He tried to apply it. It's it's robust, but it's not infinite. And so I'm going to have to slice around it, And as memory serves, it was John Hopkins who wanted any of it in at all, because I think Maya's team was happy to exclude everything relating to Chapter 39. I think they were happy to keep everything out. I think it was Johns Hopkins who wanted the defense, right? They wanted the defense, and they're like, what if we just ignore it? And John Hopkins is like, no, we want the defense. So the judge was forced to do this, as memory serves, at John Hopkins' request. Right? The defense would have been happy, let's just keep it all out, right? That way we don't have to break out the scalpel. John Hopkins is like, no, break out the scalpel. Now they're sad the judge put the scalpel in the wrong place. But they're not being specific about how the judge put it in the wrong place. They're just saying he got it wrong. Could you be a little bit more specific about how? In what way? Other than just saying it's broad. Other than just saying, well, this is to be broadly construed. This is a broad statute that's broad and therefore, right? Could you make it a little bit more more exacting would be nice. I mean, okay.
These situations are always terribly sad. And if angry parents can bring lawsuits that quibble over details, you were allowed to do this, but it didn't expressly say you could take the iPad, so I'm going to say you maliciously took my iPad in order to make me miserable, and I'm going to talk about how sad I was for 97 days, and I'm going to have experts refer to my hospitalization and sheltering as a captivity. I'm going to use this language of kidnapping, abduction, and torture.
Was there an option where she could receive care when the trial court was considering the shelter?
It was a fluid situation. There was the initial detention, which was done by the hospital, and that's under 39-395.
And that's their initial report. That deals with their initial report.
There are even two initial reports. There's an October 7th report and October 9th report. The October 7th report, the reporter says the parents are cooperating, they're doing what we want to do, and DCF's response is, well, then we're okay. Then if they're doing what you suggest, that we'll leave it alone. 2 days later, they call back and they say, we have much graver concerns now because of what we've learned in the last 48 hours, and an investigation is opened. That point creates enormous protection and immunity for all of the good faith child protection activities. Again, if you're operating in bad faith, that's an entirely different matter and you're not protected. But good faith child protection activities must be broadly protected, because if someone is on a 91-day sheltering 24 hours a day for months on end, who is able to get, just through testimony, someone said this, I didn't like the look on her face when I was talking to my mother. I mean, they go to trial over facial expressions. I didn't like Kathy Beatty made bad faces when I was talking to my mother. And when they're saying she also constantly interrupted when my mother and I would stop speaking English and began speaking in Polish. Well, that's in the order. You've limited, they're worried about the psychiatric dynamic and the pressure being put on the child by the mother, and a clear stipulation is, or not stipulation, a clear part of the order is, these are going to be monitored calls, and of course they have to be in English. If you switch to a language that the monitor doesn't know, you're no longer monitored.
Can you clear up something for me related to the false imprisonment? At what point in time between the first report in October 7th and the next one, when did the Kowalskis ask to leave the hospital?
It's not entirely clear.
It's not to me either.
Yes, and I've spent a lot of time on this, and I can't delineate exactly when and where. There is the testimony, we were threatened, we'd be arrested, and the light most favorable, we have to go with the assumption that they did detain the child. I can't identify what day, what time that happened. But there's also, throughout the medical records, repeated references to extensive communication, family meetings, and consent. They agree to placing the nasogastric tube. They agree to a colonoscopy.
And then they later agreed to stay at the hospital.
Yes.
At some point in time. I guess my next question to follow up on this is, were they forced to stay? Because there's some allegations here that they would only leave if the hospital would remove the Munchausen by proxy syndrome from the records.
So let me interrupt that. We do want you to answer the question, but you're in your rebuttal time.
All right.
But please answer the question, or else I get yelled at.
I'm sorry. Could you please?
Was that, is that an accurate depiction of what happened, that they were not allowed to leave unless they agreed to the theory of the hospital that she was a victim of the Munchausen by proxy?
Thank you for repeating it. That's absolutely false. That is what they present as their interpretation. The medical record is prepared. The hospital wants to transfer them to Nemours. The family wants to go to Nemours. But the mother's intent, I want a clonidine pump that is inserted into her spine that provides these massive painkillers. And Dr. Santana Rojas at Nemours says, well, we're not going to do that. Dr. Rojas is a CRPS expert. And the Hopkins throughout admittedly said, we are not CRPS experts, but we are professional child anesthesiologists, pain management experts, pediatricians. This is one of the elite hospitals of Florida. There's a lot we can do, but we're not the ideal place for this case, which has a psychiatric dynamic and a CRPS dynamic, and we want to move you there. The parents spike the plan. They do have to consent to the move. The hospital's ready, Nemours is ready, and they say, take out this part about suspected Munchausen. And the hospital says, well, no, that's the medical record. That's the honest view of the hospital. And they argue at trial, this meant we would have had to agree to it. It doesn't mean that. You can write, that's what you think, I disagree. And that's just what's thrown to the jury, is we were trapped because we would have lost our license. But that's the medical records. There's no right to change the medical records, not to correct errors, but to adopt our theory that we are not child abusers before you consent it. There's no right to do that, and there was no barrier to doing that. Thank you for the time.
Thank you.
All right, on the whole, in sort of analysis of this attorney, I think this attorney is perfectly serviceable. He's a good attorney. You know, he's faced with a difficult case, and he's faced with, you know, Johns Hopkins did some bullshit, and he's decided, you know, in his capacity to try to fight multiple different grounds, which, you know, trying to figure out what to fight as an appellate attorney can be challenging. You know, what issues do you raise? You know, obviously anything you don't raise, you lose. But that doesn't necessarily mean you should raise everything, because sometimes something that's weak can hurt your overall case. So you have to make a strategic call about what to include and what not to include. This guy made a perfectly reasonable strategic call. The chapter 11, you know, child immunity stuff in the statute, I don't think is really going to go in his favor. It doesn't seem like the court is particularly inclined to go that direction. It seems like the court feels like some things were done outside of the scope of the immunity. And so I don't think they're inclined to go that direction. As to whether or not these state people, whether or not these government employees were purely governmental employees, seems like an issue of fact to me, right? Is this person acting in a capacity purely as a government employee, or have they now become a hospital employee? Incidentally, by the way, the doctor was wearing the hospital coat, right, with the hospital's logo on it, right? They literally clothe themselves in the hospital's imprimatur. So that kind of goes a long way to saying, you know, well, maybe you're an employee of the hospital in addition to your governmental function. So that's a real problem for you. I thought his answer on the distinguishment from the one case that Florida does have on the intentional infliction of emotional distress relating to self-deletion was a good argument. And he didn't really, what was interesting actually, and I don't know if it's a time thing, but what actually interested me is he didn't actually get into whether or not the numbers are just purely excessive, right? Because that's an argument I would have been more inclined to, well, I would have been inclined to raise, right? These numbers are just wildly out of sync with anything else, and they're just grossly disproportionate. Interesting, he didn't really raise that argument. He didn't really raise the argument that, you know, even assuming that Maya's case, these numbers are just wildly out of whack, you know, using some sort of comparator analysis. So I'm not sure exactly why he didn't really raise that issue. Maybe it was in his briefing. Maybe he just didn't get around to it because appellate arguments can be so short. He's not given much time. Maybe he just didn't have time to discuss it. I don't know, but it seemed like a bit of a waste opportunity. But, you know, on the whole, I have no objections with this attorney. On the whole, this attorney is perfectly fine. He's a good appellate attorney. He's argued the case. He answered questions from a somewhat hostile bench with poise and professionalism. So, you know, good job. All right, good job. Let's see how Maya's lawyers do in their response.
You'll have your license.
Thank you.
Mr. Tanner?
Good morning, Your Honors.
Good morning.
Mike Tanner, Gunster, Yoakley, and Stewart for the appellees. Judge Smith, I'd like to begin by answering your questions and the two last questions that you asked, and then follow up on the questions that you asked, Judge Black, about the scope of the immunity. But I would like to start out with your last question on when the Kowalskis were told they couldn't leave the hospital. And you heard my colleague say that it's not clear. It's actually very clear. It's at page 3208 of the transcript. In Jack.
Burn. right? He's got receipts and he's got page numbers. Yeah.
Kowalski testified there that they arrived on a Friday afternoon, October 7th, and he said there that on the following Saturday morning, the next morning, he asked to leave and was told he could not or they'd be arrested. So 3208, and then look at his testimony, page 3265 and 66, where he elaborates on that.
And by the way, when they were told they can't leave the hospital, of course, is a question of fact, right? That's a question of fact. And of course, the Court of Appeals is going to assume all facts that support the verdict, right? Because the verdict is the verdict, right? Now, they might have legal questions about the verdict, as we sort of discussed, right? These amounts are just wildly out of sync with comparators. That's a legal argument. These amounts are unjust, fundamentally unjust. That's a legal argument. There's no liability for Maya's mother's death. That's a legal argument, right? The whole chapter immunity thing, that's a legal argument, right? Those are all legal arguments. But when was, Kowalski told they couldn't leave the hospital? That's a question of fact. The jury, we assume the jury found every fact that will support the verdict, right? Because they reached a conclusion. We will assume every single fact necessary to support that conclusion. So we do know, for a matter of fact, when it happened because they testified to it. And since the jury found in their favor, it must be true, right? The jury must have believed them. The jury must have found that fact to be true. It must be true. So now it's a fact. It is a fact. We do know when. Burn and die.
And then, and I think this is important also to your question, you don't need to accept Mr. Kowalski's testimony about that because it's actually in the medical record. Look at the record at R109-987. And that is a record by Dr. Voss that was done in the early morning hours of the following Tuesday. After she
this guy's
had a
got receipts, baby.
With Beata
this
Kowalski.
guy's got page numbers from the record. This guy's got receipts. Stellar.
That evening, in which Beata said, we want to take Maya out of here tomorrow morning, Tuesday morning would have been the 11th, to take her to an appointment with Dr. Hannah, one of her treating physicians. And Dr. Voss goes in and memorializes in that record what the hospital's response to that was going to be the following morning. And it was that leaving with Maya was against medical advice, and therefore they would not be allowed to leave. And if they attempted to, security and risk management would be called. It's right in the medical record. And
oh, that's nice. The hospital documented it for us. So in addition to, you don't have to believe, Kowalski, you can just believe the hospital because they put it in their own records. Nice.
The documents that counsel referred to that show that purportedly the Kowalskis agreed to stay at the hospital, those are all cited at page 13 of their initial brief. I commend those to you. I want you to read those because what those actually show is that those are all dated the 12th or the 13th. After they'd been told what they were told and memorialized in the record on the 11th. What those show is that the Kowalskis are attempting to accommodate themselves and get along as best they can in the circumstances they find themselves in. And they're agreeing to do some things the hospital is suggesting and disagreeing with other things. But at no point is there anything in the record where they agreed that they would stay there and that that's something they wanted to do. And I just wanted to start off with that. And I will add this as well. I think what you heard this morning was very much like their brief. And what's remarkable about it is the number of factual disputes that they continue to assert and factual issues that they continue to believe.
Ooh, yeah, that's like, you don't want to do that. Or that's yeah, you kind of have to take the facts as given now because you're on appeal, right? You have to take the facts as given because the jury finds facts. That's what they do. That's their job. So you don't go to the Court of Appeals to dispute facts, right? Unless you're going to make the argument the jury's finding of facts is so batshit crazy, right, that it defies all reason and understanding. No reasonable jury could possibly find any of these things. They're batshit nuts. Unless you're going to try to make that argument, dude, man, don't go to the Court of Appeals and argue about facts, dude. The Court of Appeals is going to hate you. right? If you're still grousing about the facts in your appellate brief, geez, man. I mean, it's like, dude, no, just no, don't do that. The Court of Appeals is going to hate you.
Continue to believe that they can litigate here with you in this court.
Yeah.
They dispute, for example, that ketamine was efficacious for Maya. They dispute, as you heard just a few minutes ago, that they told the Kowalskis they couldn't leave the hospital. They dispute that they put Maya in the room to video her and that she soiled herself. They dispute that still. They say that it was for medical treatment, yet it wasn't in the medical file. Counsel said to you...
Yeah, it was for medical treatment, not in the medical file. It was a nice little moment of the trial, right? Remember all that stuff, right? Because like certain things they did, it's like we did for medical treatment, but it wasn't in the medical file, like the photographs we took, right? The photographs we took of her. We were photographing her because we thought that they were bruises. Oh, that's interesting. Why aren't the photographs in her medical file? Why are they a risk assessment file? Why aren't they in the medical file? They're for the purposes of medical diagnosis, right? Yeah, it's like, the jury didn't seem to believe they were for the purpose of medical diagnosis. Yeah, that sounds problematic.
This morning that there was an assistant risk manager approved putting her in there. Well, it wasn't an assistant risk manager. It was the risk management department. And we have documents in the file we gave you that show the very senior people at the hospital who were involved in the risk management department. So I wanted to kind of start off with that to give you a flavor of what we perceive as a very, very factual kind of presentation in the brief and here this morning. And all those issues were submitted to the jury. And the jury found against them on those issues. And yet they want to litigate them again here in this court.
Yep.
So Judge Black, and Judge Smith, you asked this question too as a follow-up on what is the scope of the immunity. And I listened very carefully to my colleague here in answer to your question, Judge Smith. Well, what about tortious conduct? Would that be immune? And I think I got a concession that it would be in theory, but then what was that? We have torts here. That is, the jury found torts in this case, and yet we don't have a concession that those torts would be subject to the immunity. We have some other torts, I suppose, that would be. But if you go through their brief, I think the residual point is this. They contend that everything that followed in time from the act of reporting should be immune. They don't say it that way, but if you read their brief closely, look at pages 24 and 25 of their reply brief, I think it becomes clear there. Everything after the act of reporting, they say should be immune. It would be good faith sheltering in their words. So there are two reasons why that's wrong here in this case in particular, but generally. And the trial judge, I think, drew the line very correctly and very carefully between the immune and the unimmune. It's wrong because the statute that we're talking about, and it's 39203(1)A, immunizes certain types of conduct. It immunizes reporting, and the trial judge gave them that. And counsel here said today that they won a certain number of claims. I want to make sure we are talking about who won those. The hospital won those. The false and the malicious prosecution, the abuse of process, the negligent infliction claims, the interference with parent-child custodial claims, all of those were tossed out by the trial judge on Chapter 39 grounds. So they won those claims, not the plaintiffs. But the trial judge correctly ruled that the things that are immune are the claims and the liability that logically follow from the act by reason of reporting. And so he eliminated all those claims I just described. But then he went on and assessed the remainder of the claims under the remaining language of Section A, which they ignore. And we're asking you and believe that you should apply the full language of the statute. And the remaining language in Section A, and Judge Black, this particularly goes to your question, I think. Section A immunizes reporting, but it then also immunizes conduct that is authorized or required by Chapter 39 and undertaken in good faith. And, Your Honors, there's no such thing as a good faith tort, especially a good faith intentional tort.
Nice.
And nor is anywhere in Chapter 39 tortious activity authorized or required. And so that was the trial judge's analysis, which we suggest was correct. He looked at the nature of the conduct and decided if it's tortious and it's not clearly required or authorized by Chapter 39, then it would be an issue to go to the jury, in answer to one of your questions, Judge Smith. So, so that's partly why they want to exceed the statute, or ask you to exceed the statute when they ask for what would essentially be blanket immunity. But the other problem is this: they ignore Section 1B, which goes on to say that any person, which would include a healthcare provider that itself abuses children, is not subject or does not get immunity for any of that. And the trial judge ruled that this kind of conduct, based on the allegations, would fall squarely under that. And that, and the authority for that would be the Yamani case and the Floyd case that we cited. So, Your Honor, I hope that's an answer to your question. I think that's the scope of the immunity, and that's what the trial judge did, and we say he did it correctly. Yes, sir. So, Judge Smith, I do want to also address your question on Nelson. And I think you summarized quite well all the conduct that we laid out in our brief on the application of that case to the IIED claim. Two things I would just say about Nelson. In their brief, they predicted that there would be this avalanche of litigation if suicide causation claims were allowed in the state of Florida. Well, that hasn't occurred. Nelson was 43 years ago, and there's been no avalanche of litigation. And I think the trial judge correctly ruled that under Nelson and under the Tate case, which is cited and is the basis of the Nelson ruling, that his jury instruction was absolutely correct, where he gave it a two-prong instruction of the substantial factor, which comes right out of Tate, and also the uncontrollable impulse, which comes right out of Nelson. So you would be following the first district if you applied that analysis and affirmed the trial judge on that instruction. And I will say this as well. Counsel said it again, they said it in their brief, that, well, Nelson is an outlier, and also it's based on FELA principles. I think if you read the case, you'll see it's not based on FELA principles. Tate, which it relies heavily on, is a common law case, relies on majority jurisdiction, American civil trial tort principles. And then Judge LaRose, I do want to get to one of your questions. I'm sorry it took me a while to get there, but you ask, what are the duties of the parents under the shelter orders? And I think it's important.
Specifically, what was the hospital's duties?
Yes, sir. What were the hospital's duties under there? And the trial judge, at the request of the hospital, gave an extensive instruction on that to the jury. And one of them was, to Judge Smith, this goes to one of your questions too, the parents were permitted to participate and be consulted on medical decisions regarding Maya. That's right in the order. But the other terms of the orders were that the parents were to have communication with Maya. They were to be allowed to have certain types of visitation with her. The husband and the father and the brother were allowed communication. The mother was allowed telephone communication at first. Later, that was expanded to allow FaceTime. And they were allowed written communication with her. So, and as we said in our brief, the hospital's refusal or failure to carry those out was part of what we contended was the part of the IIED claims.
Yeah,
and
fair enough.
Those come right out of the shelter order requirements.
Yeah, they defied the order, right? They defied the order because the order itself, as he says quite correctly, had issues, had things in there for the parents' ability to contact Maya. And at some points, the hospital actually stepped in and interfered with those communications, wouldn't allow those communications in defiance of the court order, right? In defiance of the court order, which specifically says it. It's like, well, how can you possibly be protected by the order when you're openly defying it, right? It's like, that doesn't really make sense. So, and it's like, we thought this was part of a pattern of conduct. It's like, yeah, okay, that makes sense. So, yeah, hospital's got problems.
I do want to address the points he made about Dr. Smith. the fact is, they said it in their brief. Dr. Smith did not present well as a witness at trial.
Nope.
And I'm sure they regret calling her. The fact it was that the plaintiffs played one deposition clip from her. It lasted about 30 minutes. The hospital called Dr. Smith to the stand and kept her there for quite a while. And so if there was any sort of prejudice to the optics of the case from Dr. Smith's presentation, the hospital bears the responsibility for that. But I think it's important to remember also that Dr. Smith and her apparent agency was an issue in one claim out of all of these, and that was the medical negligence claim. It was not an issue in any of the other claims. All of the other claims are based on the acts of other individuals and in the hospital, none of whom were shown to have any relationship with the CPT or the dependency court. It was only the medical negligence claim.
It's very interesting to me noting how few questions the bench has for him versus Johns Hopkins lawyers, right? Johns Hopkins had the lawyers, the judges were jumping down John Hopkins' lawyer's throat. And here the judges basically have no questions. It's like, right? That can be concerning to you as a lawyer, because it could be read as they're disinterested. It could be read as they don't care, they're disinterested, and they've given up, and they don't really care about anything you're saying. I'm not sure that's the situation here, though, given the hostility of the questions to Johns Hopkins. So I have to read a little, but it's amazing to me that he hasn't gotten any questions, whereas John Hopkins' lawyer couldn't get a word out without the judges running down his throat. So I guess he's winning. Lol.
And the verdict form for the medical negligence claim laid out two questions, or three questions actually. Is Dr. Smith an apparent agent? Yes or no? If the answer to that question is yes, was she guilty of medical negligence? Yes or no? But then it went on to say, were there any other employees of the hospital other than Dr. Smith whose conduct rose to the level of medical negligence? And they answered that question yes, because there was abundant evidence in the record of other medical practitioners who were involved in the treatment of Maya. And so you really don't even need to reach the issue of Dr. Smith, because the medical negligence verdict is, you can affirm that on the conduct of all of the other doctors. And it was the other doctors in the hospital, Dr. Vose, Dr. Teppa, Dr. Dees, who made the decision to terminate
Dr. Dees nuts?
Maya's ketamine. And that's the basis of the medical testimony that Dr. Chopra testified, that it was the termination of the ketamine, which was an efficacious treatment for her, that permanently aggravated her CRPS. And the hospital has not challenged the admission of that testimony in this appeal. And I also would like to, on a related point to what was going on in the hospital would like to give you the impression that everything that was being done to Maya, what she could see, where she could go, who could see her, who she could talk to, all of that was being controlled on a very granular level by the DCF. I want you to read the testimony of Catherine Beatty at pages 3962 through 3970 and 4000 through 4004, because she was very clear there about what it was that Johns Hopkins was dictating, what their discretion was, the decisions they were making through the risk management department versus DCF. And so it's a significant exaggeration to say that DCF was involved in the details of what Maya could do, the scheduling of phone calls, whether she kept her bathroom door open. That was all done by the hospital. Those decisions were made by the hospital. I think I've answered most of the questions, if not all of them, that you asked. Are there any other questions you would like to ask me at this point? Because there's one final point I would like to make, but I want to answer your questions first.
Nope.
All right, well, let me lead with this. I think on the damages, the hospital in its brief more or less went through all of the damage numbers and threw their hands up and said, this is all excessive, there's no evidence that supports any of this, please reverse it all, give us a new trial on all of it. More or less, that's what they said. If you look at the damage numbers, and the numbers are large, no doubt about that, but we have to remember that these injuries were done to a 10-year-old child who then would suffer those injuries for the rest of her life, which would be a long life from that point, from 10 years old to 70 or 80. And the medical testimony from Dr. Brewerton was that because of the events at Johns Hopkins, or he uses the term events, she suffered permanent aggravation, she suffers PTSD, and then he said from the experience she had at Johns Hopkins, she suffers major chronic depressive disorder. And that testimony was not objected to by the hospital, and it was not, the admission of it was not challenged as a point on appeal in their initial brief. So that's the medical testimony. The damages testimony was tried as a unified damages case on economics, was $15 million from Ms. Kirby, and they have not objected to that testimony, and they didn't raise it as a point on appeal in their initial brief either. So that testimony was established by competent substantial evidence, $15 million. If you then take the non-economic award, which totals for all the torts on Maya now, that totals $69.5 million. That's a 4.5 times multiple of non-economics to economics. This court, in the Ailes case on remand from the Supreme Court, left undisturbed a non-economic award that was 16 times the amount of economics. So we submit in that light, and remembering that this was a 10-year-old child, these numbers, even though they're large, look very reasonable. And so, again, unless there are questions, we would ask you to affirm, and we stand on our papers.
Give you your full 5 minutes to rebuttal.
Thank you, Your Honor. I want to emphasize that there is a difference between...
He's a fine lawyer, different style. The other lawyer, I apologize, Maya's lawyer, very different style. He came a lot quieter. He came with receipts, which was appreciated. The fact that the judges basically had no questions for him is kind of blowing my mind a little bit. It's like, that's so weird. To go up there and like not have basically any questions, a completely quiet bench. I tell you, if there was a quiet bench, it would freak me the fuck out. Like, cause they have no questions for me. Like nothing. It's like, man, it's like you're resigned. Now resigned to what, I guess is the real question, but it's like, man, it's, I liked his style. I thought he was good. He answered the judge's previous questions. He rebutted basically his friend from the other side and on every point. And then he gave the point about why he thinks the damages awards are valid, basically just saying Johns Hopkins has just thrown their hands up in the air and say it's excessive without really defining that. So basically not really saying it, and then basically saying that no, the awards are fine when you look at the numbers and you look at the motables. It's like, well, okay. So we got 5 more minutes from this guy, apparently. Although there's 7, yeah, there's 8 more minutes of video, but we're supposed to be 5 minutes. So we're going to get 5 more minutes of rebuttal time. This should be good. No questions is usually good. No questions, I think, would be actually usually bad. If I had to say no questions is usually bad, because it means that they don't care about anything I have to say. All right, they're resigned. They don't care about anything I have to say. It would make me very, very nervous. So, but given the way that they treat Johns Hopkins lawyer, I'm not sure that's the problem here. But yeah, it's probably bad.
The evidence and the reasonable inferences that can be drawn from the evidence versus rhetorical expansion. And a lot of this case deals with, and something like ketamine efficacy. What are the reasonable, and what is the evidence of ketamine efficacy? Maya Kowalski showed up at this hospital having not just been put in a ketamine coma that had her at, and the science is it's milligrams per kilogram per hour. But that coma in Mexico was at the rate of 3 milligrams, 4 milligrams, 5, 6, and 7 for the 5 days, because tolerance builds. The day before she arrived at Hopkins, she was infused at 24 milligrams per kilogram per hour.
See, this is not the thing, though. This is the problem, right? Like, you're missing the point, or at least to me, you're missing the point, right? Was Johns Hopkins, were they legitimate in being like, these ketamine numbers look crazy? I'm really concerned that, Maya's gotten some quack doctors out there who have been prescribing some really BS treatments. Like, was that a reasonable thing for Johns Hopkins to think? Yeah, you bet your ass it was reasonable for them to think that. Was it reasonable for them to call CPS in view of that? Sure. Why not? But like, that's not the thing, right? Johns Hopkins' concern is not the thing. Well, the concern is what they did as a result of that concern, right? It's not that they made the report. It's not that they were concerned that their other doctors were quacks. That's not the thing. The thing is, what did they do, right, as a result of those beliefs? And that's the problem. So he wants to go back and basically be like, because these ketamine numbers are so unbelievably high, therefore everything Johns Hopkins did is necessarily okay, because it was all in good faith based off this stringent concern. And it's like, no, it doesn't quite work that way, right? It's like, no.
The doctor treating her said, I'm out. I have failed to treat her. You need to take her to a hospital. There could be bile duct inflammation, but this has failed. She rated her pain 10 out of 10, her quality of life 0 out of 10, and she showed up screaming in excruciating pain. Her testimony is that my lesions were returning. The idea that ketamine efficacy is just the law of the case, that this worked and the hospital, ruthlessly just ripped it away to get the mother to kill herself.
That's not the issue.
Conspiracy theory. The evidence, and it's
that's not the issue. I thought it was the issue for a long time, incidentally, because Johns Hopkins tricked me into thinking it was the issue. And it took me a long time to understand what the issue is, because Johns Hopkins tricked me. You guys might remember some of the earlier streams when I was like saying, like, I don't think the jury's award is sustainable as a matter of law. I just don't see it, right? Because Johns Hopkins tricked me. They tricked me into thinking this was about the ketamine. And it's not. It's not about the ketamine. But they're still trying to pull this trick. They're still trying to pull the trick. I'm like, okay. All right. Good luck with that, I guess.
The conspicuous failure to specify what is the extreme and outrageous conduct. I hope the panel is unanimous that there's certainly not extreme and outrageous conduct that is clearly directed at the mother to get her to commit suicide 3 months after she last left the hospital. But things are thrown in there.
Fair enough, because a lot of the things weren't said to Maya's mother. Either they were said to somebody else who then related to the mother. So you got proximate cause problems, you got actual cause problems, you got duty issues, you got intervening cause problems with Maya's mother's death. Yeah. It's yeah. You got problems out the ass. My bet is that the court will throw out the cause of action with Maya's mother's death. If not this court, the Supreme Court of Florida. One of them. Well, I suppose all that really matters is what the Supreme Court of Florida does in the end of the day. So the question is, what will the Supreme Court of Florida do? I think that at the end of the day, they're going to throw out the cause of the death of Maya's mother. I think they're going to throw it out. It's just too problematic legally to recognize it. It's nightmare fuel recognizing it, right? It's just. So I mean, I could be wrong. We'll see. But my bet is that cause of action is going to disappear in the end. But it's a tough case. It's a hard case. And as this has been said by others before, hard cases make bad law. This is exactly what they're talking about when they say that. Hard cases make bad law. This is what they mean, right? No one's happy that Maya's mother's dead. John Hopkins is a bunch of bastards, right? No one's happy that Maya's mother's dead. John Hopkins is a bunch of bastards. Everyone would like to see John Hopkins pilloried. We all get it, right? So our natural desire is to make John Hopkins pay until it hurts and until they get it, which they never will. So like, you know, our natural impulse is, you know, perhaps the problem. This case sucks. Yeah, exactly, Tony. Just this one time. That's the problem, right? That's exactly the problem, Tony. That's the problem in so many words. Just this one time. Yeah. This case just this one time. Yeah, that's the problem. Yeah. So I think in the end, John Hopkins will win that point. We'll see.
Asked on the stand, you know, oh, did you have conversations during the last 10 days? Did they cut you off? And she said, oh, I didn't even know I had that right. Well, the medical records from December 30th to January 7th reflect 13 interactions between Maya and her mother. Most of those were video chats. And I want to read into the record. If you look at the record at 108-560, at 111-906 to 910, at 111-915 to 916, at 112-602.
Bitch, no one cares about all the times that Maya did talk to her parents. No one fucking cares about all the times she did talk to her parents. We care about the times that John Hopkins didn't let her. This is a very dumb argument, right? This is an incredibly dumb argument, right? This would be the rough equivalent, right, of a spousal abuser saying, let me tell you all the times I didn't beat my spouse. I didn't beat her on Tuesday. I didn't beat her on Thursday. I didn't beat her on Friday. I didn't even beat her on Saturday after I'd been drinking a lot. And I didn't beat her on Monday, and I didn't beat her on Wednesday. Look how great I am. Look how great I am. Bitch, we don't care about all the times you didn't beat your spouse. Fuck you, right? We care about the times you interfered with Maya's parents in a way that was in violation of the court order. Look at all the times we let them talk to him. That's some bullshit. That's a bullshit argument. Fuck you.
Through 6/11. That does not count the times when they called the mother and received no response, which are documented at 108, 560, 61. So the hospital is whipsawed in the light most favorable standard does not extend to making unreasonable inferences from the record. Now, they say that risk management made these decisions, and they presented a chart, an org chart that says throughout the hierarchy, these are all connected, therefore risk managers are very senior, and you can attribute that. Well, Dominguez versus Florida Power and Light says for punitive damages, you need actions from the equivalent of the president or the primary owner of the company. We have nothing remotely close to that here. There's no basis for
I don't know about
damages.
that. I don't know about that.
The awards that they're trying to make sound reasonable. There was a battery claim for this social worker who was a grandmother hugging this child when she was crying and upset and putting the child on her lap.
Yeah. Yeah, I mean, basic law 101, right? Basic law definition of battery. What is battery? What is battery? Well, battery is any touching that either is that is unwelcomed by the person receiving it, that either is of a nature that society is prepared to recognize, or that you, as the batterer, know the person doesn't want. Okay? Although in Florida, to be honest, in Florida, battery goes even further than that, because Florida has a very weird definition of battery because it's so extreme, right? In Florida's definition, it's basically any unwelcome touching, which is very expansive. It's like, so in most states, if I touched you on the shoulder to get your attention, that would not be battery, right? Presuming that I know that you don't want that, right? Just presuming you're a stranger, right? You're a stranger to me. I know nothing about you. I tap you on the shoulder for the purpose of getting your attention. That's not battery. In Florida, if you don't want it, it is. So Florida's definition of battery is even more expansive. So either way, like, right, yeah, she hugged him and like did all these things, but that's battery. Especially in Florida, it's battery. Because Florida's battery law is a little cuckoo, but that's okay.
Happened that she kissed her on the forehead and kissed her on the cheek. Jury awarded $19 million for those hugs.
Yeah.
The allegation wasn't she was screaming in pain and she bear hugged her to torture her. This was acts of affection that the child didn't want. Does that state a cause of action for battery? Technically, yes. If my grandmother pinches my cheeks after I tell her to stop, I can sue her for battery. You have bodily autonomy. So there are claims that you can bring in the context of a sheltering case. But to say these awards were reasonable or that there was any basis for punitive damages is wildly off the mark. I want to also...
Can you just clear something up for me? With the reporting that was made initially on October 7th, it did not transpire to anything on the initial report. And the timing of it, they wanted to leave. Would they have been allowed to leave at that point in time?
I think based on the evidence, and we can assume...
The initial report didn't go anywhere.
Correct. We can, on the light most favorable, and Mr. Kowalski's testimony, we can say that it shows the hospital did not allow them to leave or threaten them with arrest and call police officers. The issue then is whether 39395 authorizes that conduct. And it most certainly does for the first 24 hours. The statute then becomes ambiguous. It says the hospital can detain a child against the parent's will, and that is an express authorization to pediatricians and to hospitals. You can take a kid from their parents when they say, "Give me my kid," if you think this child is in danger. There's no dispute that the hospital, to their core, believed at all times this child was in danger in her mother's presence. Now, the court throws out the 24-hour rule, which is a rule that applies to DCF. The hospital can seize and the hospital has to immediately report. It did both. Then DCF has 24 hours to act. And other states write it differently. If you look at West Virginia statute, it says at 96...
What the fuck do I care about what West Virginia statute says? What are we doing now? What do I care about West Virginia? I'm in Florida. What are we talking about?
Hours, the power to detain a child expires by operation of law. There are statutes that tell the hospital you need to let go of the kid, but the false imprisonment here requires unreasonable, unwarranted, and unlawful action. And even if the panel sees 395 differently than we do and says, well, that wasn't lawful under 395, it is still reasonable and warranted that when you think this child could die if she goes out the door with this parent, because we are just terrified. And
but it was okay for them to be transferred, even though those two reports had been made.
To transfer to Nemours?
Nemours.
Yes, Nemours.
That would have been okay under 39. Under the reporting, for them to be able to go to another hospital.
Yes. The Nemours was a safe place and had CRPS treatment and psychiatric care. So it checked whatever box.
And any sheltering would have transferred with that, because we're going to a different jurisdiction. I'm just trying to figure out the logistics.
They would have to get approval from the dependency court, and I believe that there was no indication.
Yeah, that's the thing. You just gave up the game there, sir. That's the thing. You just gave up the game. They would have had to get approval from the court. Yeah. Right. That's the problem, right? So your theory of the case apparently is that the hospital has the right to seize the kid for an indefinite period of time in the absence of any court order. Interesting, despite the fact that there's this 24-hour language in the statute. Yeah, I don't think so, man. Yeah, he thinks the 24-hour just applies to DCF. I'm like, I don't know, man. I don't know. It's like, what hospital does what authority does? See, he doesn't say the statute. He's just like making shit up about the statute. He wants it to say more things than it does. He wants it to say more things than it does. It's like, no.
That was not achievable. Yeah, if the parents are in agreement, the hospital's in agreement, I can't imagine if not DCF objected. But one thing I want to direct court to in my waning time is...
Counsel, I just wanted to point out you're over your rebuttal time, but wrap it up.
If I may, I would commend to the court again the court's January 14th, 2022 order on Chapter 39 immunity. It repeatedly swings and misses on what this immunity is. It expressly and explicitly ties it to reporting and nothing more. That clear error under Special versus West Boca, unless they can show there's no reasonable possibility that that error or the other two errors we've identified affected the outcome, we are entitled to a new trial. And for that reason, the hospital asked for a new trial that does not include the suicide claims or the fraud claims.
Good luck.
And properly applies Chapter 39. Thank you so much for your generosity.
Very much. Thank you to both of you. Very well argued. Very sad case.
Yes.
All right, that's the end of the oral argument. So I don't think they're going to win on their immunity. I don't think Johns Hopkins is going to win on their immunity argument. I don't see that working. The court does not seem interested in anything he has to say with respect to this immunity argument. I mean, when I read the briefing, it's been a while, but when I read the briefing, it looked... The trial court's reasoning seemed okay to me. And yeah. So he might win on the suicidality claim. That's his hope. Right? That's his hope. And that'll be really interesting to see what the Court of Appeals does with that. You know, best bet is he wins, which would reduce the damages in about half. So yeah. And as to like the excess amounts, it doesn't seem like he made the right argument, so I don't see that working. And then of course we're off to the Florida Supreme Court, where I figure that there's an extremely high chance the Florida Supreme Court takes this case. Yeah, I figure it's almost certainty the Florida Supreme Court takes this case. It's like way too high profile. It involves too many interesting legal issues. The immunity issue in particular, like no matter which way the Court of Appeals goes, you got to figure the Supreme Court of Florida wants a poke at it. So I figure there's like a 99% chance we're off to the Supreme Court of Florida. Yeah. And then the Supreme Court of Florida has to decide whether or not Maya's mother has a cause of action or not. Fun, right? Does Maya's mother have a cause of action? Rough. How much do I think they offer to sell for? I don't know. I don't even know if there's an offer for settlement. Johns Hopkins has their heads so far up their ass. I don't think there's an offer. I don't think there's ever been an offer. I don't think there's been an offer worth anything. They probably offered like $20 million or something ridiculous. The estate of Maya's mother, you know exactly what I mean. Yeah. Yes, the estate of Maya's mother. Pedantic, yes. But yeah, that brings us to the end of this case. So I'm going to go ahead and sign off for now. I had a good time today, by the way. I went doing kickball. I hadn't played kickball in a while, but I went to this meetup through meetup.com. I went to this meetup on kickball, and I had a good time. We played 3 games of kickball. I scored a point. That was nice. I pitched for a while. I ran around for a while. It was good times. So yeah. So and I need to work on my cardio, but other than that, you know, it was a good time. So I'm going to go ahead and sign off for now. I've been on Civil Law. I hope until later, my friends, all is well. Talk to you guys soon. Cheers for now and goodbye.